Hi, everybody. Thank you so much for attending today's webinar, Workplace Immigration Compliance and Enforcement, What Employers Need to Know If ICE Comes to Visit Them. I am Deirdre Nero, and I'm very happy to have you guys joining us today for this really kind of important and timely topic. We are going to jump right in because we've got lots of stuff to cover today. If you have questions, go ahead and put them in the Q&A box. I think I tried to enable the chat, but I'm not sure if it's working or not. So if not, go ahead and use the Q&A box, and I am going to try to do my best to answer as many of these questions in the Q&A as possible. Okay. It says chat is still disabled, so don't worry about the chat then. Just go ahead and anything you need to comment on, go ahead and put it in the Q&A box. All right, so make it a little bit bigger so I can see it. All right, we should be good to go. So this is a little bit about me. I am Deirdre Nero. I know a lot of you, but some of you I might not know. So in case you want to connect with me with LinkedIn, if we aren't already connected, scan that QR code. It should take you right to my LinkedIn so that we can hook up there. I've been practicing for 22 years exclusively in the area of immigration law. My focus of my practice has always been business and employment-based immigration. My firm does also handle family immigration and naturalizations and other immigration-related services, but we focus in on business and employment immigration. I've been the owner of Nero Immigration Law since 2009. So we just celebrated in February our 16-year anniversary of the law firm. So I'm really proud of that and honored to have an amazing team that works for me and helps us service all of our wonderful clients. The team, including myself, are able to service clients in both English and Spanish. And on a personal note, for those of you that know me, you probably already know this, but I've been an advocate for the National Alopecia Areata Foundation for many years. This is a cause that's very near and dear to my heart. So if you enjoy this content and you feel like you got some value out of this content and you want to pay it forward a little bit, I would love for you to support the foundation. You can reach out to me and find out how you can help support the foundation. Additionally, I love to sail. I love to travel. I teach spinning classes at the University of Miami. I have pets that I love, and I'm originally from the Northeast, from New Jersey. I was born and raised in New Jersey, and then I've lived down here in Florida for the majority of my adult life, starting mostly when I moved down for my education. I went to Florida State University, my undergraduate degree, and I went to the University of Miami for my law degree. So that's a little bit more about me. That was the end of the fun stuff. Now we jump into the real nitty-gritty of the topic. So this is the two kind of aspects of a work site ICE visit that we're going to be discussing today. Okay, there are really like two things that you can have happen to you if ICE shows up at your business. One of them, which is I'm putting, to put it in the nicest way I possibly can, is kind of the calmer, gentler version of a work site visit from ICE or Homeland Security Investigations, is an I-9 inspection. That's going to start with the ICE officials visiting your business and serving the business with a notice of inspection. That notice of inspection is going to demand production of the I-9s. It's also going to demand production of related documentation and business information within 3 days. So we'll delve into that a little bit deeper. The other side of the coin is the more kind of like scary visit from ICE special agents that they want to do more of like a work site enforcement action. Colloquially, you might hear them referred to as raids. You know, that can be ugly like you see on TV and in the movies, or not quite that ugly, but it's never going to be a pleasant experience. So hopefully we give you a little bit of we arm you with information that you can have in case, God forbid, one of these two things happens to your business, so that you feel better prepared, because really that's your best defense, is to just be well informed and well prepared. And so that's kind of the goal of today. And I hope that that's what you take away from this presentation. Also, I hope you take away the fact that you can contact me as a resource. I am here to help you guys with additional information. Obviously, we can't cover like everything in minute detail during a webinar. It's impossible. As you all probably already know, this is a pretty dense topic, and we're going to get pretty deep today, but you know, there's always more and deeper and more specific and, you know, more information. So please feel free to reach out to me at the end of the presentation. You're going to have all my contact information, and all the various ways to get a hold of me. Okay, so please take advantage of that. Okay, so we're gonna first talk about like the kinder version of the ICE visit, which is the I-9 audit visit, the notice of inspections. This is still not a good thing, right? So I'm not I'm trying to paint it as like the better of the two evils, basically. So that's how you need to think of it. You want to obviously not be involved in an I-9 audit. It's inevitably going to end up with you being penalized, probably almost at 100% of the times. You know, maybe it's not that bad if you're well prepared in advance. So we're going to talk about that a little bit right now, which is how do you best position yourself so that if you do get a visit for an I-9 inspection or notice of inspection, that, you know, maybe it's not as bad as it potentially could be otherwise. And that is preparation, preparation, preparation. Be ready. And what does that mean? That's what we're going to talk about right now. Internal auditing is really going to be your best defense, right? What is an internal audit? An internal audit is when you're going to, in advance of ICE ever asking to see any I-9s of your business, you are taking it upon yourself to do an internal review of not just your I-9s, like the actual forms, but also what are your policies surrounding how you get your new employees to fill out an I-9, how you maintain your I-9s and store them. What are you going to do in the event that you do get a visit? You know, how easy then is it for you to get the information that's required? Because remember, they're going to give you a 3 business days period, right? So that's not very long. You know, like what systems are you using and what policies do you have is also going to be key, not just the auditing of the actual documents. Okay, so that's the first basic of it. The second thing is that you want to make sure that you're auditing either everything, or you can do like a selection, right? If it's too intense for you to audit all your I-9s, you might want to look at making a selection of I-9s to audit. Now, as an attorney, I advise you, do not audit based on, or do not internal audit based on nationality or other factors that can be considered to be discriminatory. Okay, so you're not going to audit internally only the I-9s of people that you know are not US citizens, for example. Okay, that is a no-no. So you can maybe look at dates, or maybe if you have various locations, maybe you want to do an internal audit of like one location's I-9s, or like all employees that were onboarded between a certain period or something like that. But just don't base, if you're not going to do all of it, don't base what you decide to do on a discriminatory factor. And the biggest one is like, we're gonna audit all the, all the US citizens only and not the foreign nationals, or vice versa, right? We're gonna internally audit only the foreign nationals and not the US citizens. That's like a strict no. So what is the importance, right? Like, this is the key document that they're going to be looking for. You are required to have an I-9 for every employee that is hired in the US. The violations, which I'm going to show you in a moment, the penalties and violations can be pretty harsh, and can cost your company a lot of money, and potentially some goodwill and reputation as well, which is also costly in the end. There are a lot of common mistakes made on these forms. So you'll be like, oh, my stuff is good. And then you'll do an internal audit and you'll be like, wow, like our stuff was not that good, right? Like, we really we're not as like up to speed on this stuff as we thought we were. So, don't assume that just because like you have an HR person and maybe you sent the HR person to like a couple classes on this, or they did like an online training or something, or they read like the USCIS website, that your stuff is going to be error-free, because that is very rare. Now, obviously doing trainings and seminars and webinars and attending, the educational events that are available, many of them are free. And staying up to date on this stuff is going to help minimize the types of errors. But most common mistakes that we see are things like missing sections, missing documents. It wasn't done in the proper time frame. Also things like the employee didn't fill out their section completely, the employer didn't fill out their section completely, or the employee started writing stuff in the employer section. There's lots of like little things that can go wrong and cause a violation. The fines are going to range from hundreds to thousands per violation, depending on how severe it is. Okay, so this can be like painful, or it can be like really painful, right? So you want to do your best to minimize that as much as you can. I'm going to tell you about the specific penalties in a moment if you're curious about that. The other comments I get a lot is like, I don't need to worry about this because all my people are US citizens. I caution you against that type of thinking. It is just wrong thinking, basically. And the reason for that is simple. The I-9 is a requirement for every employee. It doesn't matter if the people are US citizens and completely work authorized and legal. You can still have violations on those people's I-9, right? Like, if you make mistakes on an I-9 by a citizen, like, it's still going to get a penalty and a fine, regardless of whether that person is authorized to work or not, or a US citizen or not. And that's something that a lot of employers, I think, don't have clear, like, in their brain. They're not thinking about it in that way. And that's a mistake. Now, obviously, if in addition to there being mistakes, it's also that people are unauthorized or presented fake documentation or something like that, then yeah, obviously the penalties are going to be even worse than if it was an authorized employee and it was just a paperwork or technical violation, right? But at the end of the day, either way, you're going to be facing a penalty. So keep that in mind, and don't kind of just ignore that fact, okay? All right. So this is going to help you identify your mistakes before anything bad ever happens. Now, if you're lucky, you'll never get an I-9 audit and you'll just be doing good housekeeping and you're never going to need it. But trust me, in the event that it happens, you're going to be very happy that you took the prophylactic measures to do this. You can do it on your own. But I do recommend that you work with an attorney to make sure that you're doing it the right way, and to make sure that everything is compliant properly. Because when you do a regular self-audit, you not only are going to identify what's wrong, but you're going to have the opportunity to fix it, which is the most important part. So you want to make sure you're fixing it the right way, right? So that's why we recommend that you work with an immigration attorney. But listen, at the end of the day, any internal audit is better than no internal audit. So if you are not willing, or it's not within your budget, or whatever the reason is that you don't want to have an attorney involved in this process, then at least do it anyway, because something is better than nothing. And also, if you can show that you've been kind of regularly doing self audits, you do have, in the case of an investigation, a mitigating factor argument, and I'll show you that matrix in a minute, that you had good faith and that you were trying to comply, even if maybe there were still mistakes, that at least you were doing things in good faith, trying to do them the right way and trying to like make sure that everything was compliant. Forgive me if the slides go a little wacky. The thing is very sensitive, so I touch it barely and it goes berserk. So don't get dizzy with my movement of the slides. I'll try not to make too many errors with that. Okay, so here are some best practices for your I-9 internal audits. You want to ensure timely completion of the I-9, right? The employees have to complete section 1, which is their section, on their first day of work for pay. The employer has to complete their section within 3 business days. A business day is identified not as Monday through Friday. A business day is identified as any day that the company is open for business. Okay, so depending on the kind of business, the business day and therefore how you count the days is going to be different, right? So remember that like a hospital that's open 24/7, 365, every day is a business day. A law office that is only open Monday through Friday, or else I think I would have a coup and all my employees would quit if I made them work on the weekends, is going to be Monday through Friday as the work days that you count towards the 3 business days. Okay, so just keep that in mind, that it's dependent on the type of company. And if the company is open for business, then it counts as a business day and should be counted in the 3 days. You're going to check document validity. So employers have to verify that, number 1, the worker is who they say they are. So verifying their identity. And number 2, that they're authorized to work in the United States and that the documents are genuine. You know, they don't expect you to be like a forensic scientist here or investigator, but it's, you know, let's get serious. If you've ever seen a fake social security number, you know that sometimes they're really easy to spot, right? So within reason, you need to be inspecting those documents for whether they're genuine. Now, unfortunately, it's outside of the scope of today's presentation because there's just way too much stuff to talk about today. But if you want more information about this or want to check out other presentations I've done on the topic, there is now some ways to do like alternate checking of documents where it's electronic, et cetera, et cetera. There was some flexibilities that came in during the pandemic where you were able to check basically like remotely people's documents. That was a pandemic flexibility that went away, but then they also invented after, because they saw the need for that, and especially in the advent of hybrid teams and remote work and work from home and people being kind of all over the place and not just like sitting in the place of business physically, especially since the pandemic. They did, you know, I don't give the government credit for a lot of things, but they did, to their credit, finally take the hint that a new process was needed to facilitate some remote document inspection so that every person you onboard, you don't have to be like physically holding their paper, their passport, their work permit, their green card in your hand, looking at it, touching it, right? Because that's not always possible in today's day and age. So there are some remote flexibilities. You do have to qualify to be able to use them. They are not available to everyone across the board. The main qualifier is being enrolled and properly using E-Verify. So keep that in mind. E-Verify, we touch on it very briefly in this presentation, but it's kind of outside of the scope of today. So again, if you want like more in-depth about E-Verify, let me know, because I do have some materials and presentations about more in-depth about E-Verify that I can help you out with. Okay, you want to make sure you're retaining. So remember, these are best practices for internal audits. So the third best practice would be make sure that you're retaining the I-9s correctly. you have to keep your I-9s for all your current employees and then at least 3 years after the termination for former employees. Okay, so if they're still working for you, you have to keep the I-9. If they're not working for you anymore, then after 3 years, you can purge the I-9s. I really highly suggest that you keep a system of like a tickler so that you know when an I-9 can be purged. What is the reason for that? The reason for that is that if you get audited, they might ask for I-9s that you are not legally obligated to be retaining. And so you don't want to produce things that you're not legally obligated to even have in the first place and then open yourself up to more fines on things that you weren't even like required to have in the first place. They get confused about that. You can get confused about it. And usually it's the lawyer that ends up being like, hey, you know, these I-9s that you just got fined on are all outside of the retention period. And then we can sometimes negotiate those away, right? But if you're not using an attorney or your attorney maybe is not experienced about this, like you might end up paying fines on things that you shouldn't have been fined on. So keep the retention system and keep it properly so that you do know when you can purge. But don't purge ones that you're not eligible to purge. So that's why you have to be like super careful with that. And there are really good methods for doing it that we teach our clients when we're hired to help with this stuff. And also that you can find probably online and through other resources, different methods for knowing when I-9s can be purged. 4 is going to be to use E-Verify correctly. If you're participating in E-Verify, make sure that your employees are entered into the system within 3 days of their date of hire. You're going to use basically the I-9 to help you complete E-Verify correctly. In addition to that, if those of you who are watching from Florida, this webinar is open to people everywhere. So I don't know where all of you are tuning in from today, but for those of you that are in Florida, where my law firm is located, remember that, 2 summers ago, E-Verify became mandatory in the state of Florida if you have 25 or more employees. So if you're in that situation, you should already be using E-Verify. There might be other reasons why you need to be using E-Verify, such as if you want to take advantage of the remote verification alternate procedures that I alluded to earlier. There are also other reasons. For example, if you have employees that are on STEM OPT, you need to be enrolled in and using E-Verify. And making sure that you're using E-Verify properly. Because that opens up a whole other, that we don't have time to go into today, set of rules that you need to follow properly. The next best practice is to make sure you're correcting errors properly. Never, ever, ever white out or erase mistakes. The correct way is to single line through so that the information is still visible behind the line. Single strike through, and then a correction with an initial and a date next to it. Never erasing, never whiting out. Okay. Training your HR managers and hiring managers and anyone else that is kind of in a role that is touching this area of your business. They need to get proper training. Okay, that's really important. And that's something that obviously I can help provide as one of my services, or other immigration attorneys that work in this area can help train your people. But there's also a myriad of organizations that have webinars and training sessions and different conferences. I saw Pilar here. You know, she's involved with the HR Florida conference that I speak at every year. We'll be there this year. For those of you that are going, myself and 2 of my amazing colleagues that work in this area are going to be doing a panel. So if you're at HR Florida this summer, come check that out. Where we'll talk a little bit more about some of this stuff, but training is really important. Okay. Now that's general training that I was alluding to, but also specific training. So specific training is like, not just how do you do this the right way, but then how are we doing it in our company? Right. And what are our specific policies that these people need to be trained on? Okay. So those are your best practices. Okay. So if you get like the actual visit from the ICE officer, this is what it looks like. And this makes me laugh. So this is directly from the government. You see the website there. It's from ice.gov / the link that you see there on the screen. I'm not going to read it all. This makes me laugh because you look at it and you're like, oh my God, this is like a cluster, you know what? Like it's very all over the place, right? And it's kind of like, from the lawyer's perspective, like funny that their diagram is so chaotic because, you know, that's kind of what it's like in reality, right? But here you see like kind of what happens. It all starts with the notice of inspection, which you see there at the top, right? And that's when they actually visit and serve you the notice. Then they're going to actually request your documents that be produced within the 3 business days. Hint or tip, if you're working with a lawyer, and even if you're not, you might not be as successful, but regardless, you can ask for an extension. A lot of people don't know that, right? So you can request that they extend the period beyond 3 days. And they, at least my experience over the years has been that they're relatively okay with that, and they'll typically agree to an extension. Now, they're not going to give you like a super long extension. They're not going to go from 30 days to like, I mean, from 3 days to 30 days, but they might give you 7 days instead of 3 or something like that, or 5 days instead of 3. Regardless, you need to ask for the extension, even if you don't get it, because if you don't ask, then you definitely won't get it, right? So you have to ask to even have a chance of having an extension. Even if you think you don't need the extension, I would still ask, because you don't want to be like frantically gathering stuff. You're more likely to make a mistake, right? So you want to be like a little bit more calm in your gathering of the documentation that they're requesting. And so I really suggest that you ask for the extension regardless, even if you think like, I don't need the extension, I've got everything, in order, I'm good to go. I would still ask for it just to make sure, double check, run it by your lawyer, or other eyes, maybe, just to make sure. But here's what happens. You produce your documents, then they're going to, if you have violations, then it's going to be, are they substantive and technical, or are they no violations, which doesn't happen very often. But listen, if you have no violations and you're like on top of this stuff, then they'll issue you a notice of inspection results that you are compliant. Okay, but 9 times out of 10, you're going to have some kind of substantive or technical or procedural failure. At that point, you're going to either be issued one of these notices, or you're going to be issued another notice, basically. Eventually, this is like so chaotic, I could barely read it. Eventually you're going to get to the notice of intent to fine, right? And that's where you're actually seeing all of the specific problems and how much you're going to have to pay for each one. At that point, you can actually say okay and pay it. And honestly, if you did pretty good, but you just had like a few violations and it wasn't that much, maybe you just want to pay it and be done with it. But 9 times out of 10, it's going to be like, that kind of bad. So you want to maybe then try to settle or have a hearing. What I do when I'm hired for these is always request the hearing, because when you request the hearing, that's when they want to try to settle the government, because they don't want to go to a hearing. You don't want to go to a hearing. I don't want to go to a hearing, and they don't want to go to a hearing. So the way to basically instigate the desire to settle, which is what everyone really wanted anyway, is to request the hearing. So that's typically what we'll do, and it has to be done within a certain amount of time, etc. Okay, so this is what it looks like, but it all starts with the visit from the ICE officers, which is that top notice of inspection block, and then all of this happens after. Okay, so when you're kind of in the thick of this and you're trying to settle, or you're trying to decrease the amount that you have to pay, this is kind of the matrix that's used. you can either or be neutral, but also, unfortunately, the fine can be enhanced based on this matrix as well. So that means that it can go up, right? Plus or minus 5%, basically. Business size, good faith, which is what we talked about earlier. Like if you can show that you had good faith and you were doing regular internal audits and trainings and et cetera, you know, you might get a mitigation of 5% for good faith. The seriousness of the issue can either aggregate or mitigate 5%. Whether you had unauthorized workers or not, that can mitigate or aggravate. The history. Is this not your first time going through this, right? Like, do you have what's your history with this? Or have you never ever had an issue and this is kind of the first time? So we can look at a cumulative adjustment of about 25%. Now, that's a lot. That's good. You can mitigate 25%. But you're talking sometimes about some pretty hefty fines. So even mitigating 25%, you're still going to be in it for a lot of money. So usually working with lawyers, we can mitigate it a little bit more, especially by finding things like fines on people that shouldn't have been in the retention period, for example. Or if they try to say fine for no I-9 and it's like the owner of the business who's not required to have an I-9. So things like that can also decrease the fine, right? Also, lawyers can negotiate a payment plan, right? So it's not just a matter of decreasing the amount of money that you're going to end up paying, but also how long do you have to pay it back? Because that can also be a big deal, right? Paying a big lump sum at once is a lot more damaging to a business than paying it over the course of several years, right? So that's another thing that we can work on in terms of settling. So in terms of like what the actual cash looks like, this is current as of January of this year. They do adjust these penalties for inflation. So they do, this is not a static thing here. So you definitely, as time goes on, want to be checking in on this and seeing how much it is at the moment, right? But for now, this is the most recent one that I could find. Substantive and uncorrected technical violations. Your minimum penalty is going to be $288 per violation. Your maximum penalty is going to be $2,861 per violation. These are substantive and uncorrected technical are things like failing to properly complete an I-9, failing to properly retain the I-9, failing to make the I-9 available for inspection on people that should have been produced under the whatever they requested from you, right? Typically they're going to request like a certain time frame of I-9s in the notice of inspection. Then there are fines for knowingly hiring or continuing to employ unauthorized workers. Your fines here on first offense are going to range from $716 to $5,724 per unauthorized worker. You see how high that can go. So think about if you have several unauthorized workers and each one is almost 6,000 per, right? Second offense, even more. Look at that. Look at the jump there. It starts at the highest level of first offense and then it goes almost 2 to 3 times higher, 14,308. And then substantive offenses can go as high as 28,619 per unauthorized workers. These are imposed when an employer knows that the person is unauthorized and they continue to employ them. Document fraud, that's something else you can be fined on. First offense, also pretty hefty, $590 to $4730. Subsequent offenses, $4730 to $11,000 plus, almost $12,000. These are for when you're knowingly committing acts that involve document fraud. Like fake, you know, a lot of times the documents are fake. I did an I-9 inspection once. I'm like, everyone had like a license from the same state and like a social that was clearly fake, right? Had like typos on the social and stuff. Like, you know, at some point, like you can't insist that those are valid documents when it's very obvious that there's document fraud involved. Remember that these fines are subject to increase from inflation. Okay, so I think that was it on that section. There's a lot more to say about that. I've done lots of very long presentations on just the part that we just covered. But because we also want to cover the actual like worksite enforcement action or raid in a bit of detail today, because it's a less common thing to find presentations about. But right now, due to the current immigration climate under the new administration, this is becoming more and more of a fear for employers. So this is where we're actually going to focus our time today. I wanted to add in some substance on the I-9 inspections, but the real purpose of today is starting from these slides. So if you want more detail on the first section that we just covered, let me know. I've got lots of older presentations on that, and I'd be happy to share them with you or talk to you one-on-one about that stuff. Let me quickly look at the questions and just make sure that there's do you need I-9s for contractors or agencies? Contractors, no, if they're actual real contractors who are properly classified as contractors, you don't need an I-9 on properly classified contractors. The reason I'm hedging with my language is that, especially in South Florida, this is notorious, but I'm sure everywhere in the country there's an issue with this, is improperly classifying people as contractors that ought to be classified as employees, right? So classifying them as 1099 instead of as W-2 employees. The main reason that employers do that is because they want to save on payroll taxes. But guess what, guys? It's not up to you whether someone is a contractor or an employee, right? Like you can classify them the right way, but you're probably misclassifying them unless they're like a true contractor. And so what happens is if you're misclassifying someone that ought to be an employee, but you're classifying them as a contractor, you're going to get in trouble for not having an I-9. You're also probably going to get in trouble with the IRS because there's going to be payroll taxes that you should have been paying on that person. But you weren't because you misclassified them as a contractor. You're probably also going to have problems with the Department of Labor because when they're employees, they probably were subject to minimum wage and overtime rules that contractors aren't subject to. So you can get into like a world of problems, not the least of which is an I-9 violation. If you're misclassifying people that should be employees as contractors. But if they're like a real contractor for real, and you're properly classifying them as such, then you don't have to have an I-9 on them. Agencies, typically the agency is going to be responsible for that aspect. And then you, as the ultimate employer, are going to have a contract with the agency that says whose responsibility it is, and you want to put the responsibility on the agency, not on you for I-9ing the employees. Okay, we can talk about that a lot more because it's kind of a whole other topic, but that's all I have time to go into on that. The owner of the business, you don't have to have an I-9 on yourself as an owner. I just got that question. So no. Listen, I own my firm. I I-9'd myself even though I knew I didn't need it. I don't know why. I mean, I don't need it under the law, but I still did it. So it doesn't really hurt to do it, but you can make that decision, but no, technically you don't need it. Okay, I'm trying to mark off the questions that I've answered so that we make sure that everyone gets their questions answered. Someone is asking if the employee fills out I-9 section 2, do I destroy it and ask the employee to redo it? or do I keep it as a record? If you're still within like the proper time frame, I would just destroy it and start over because it's improper, right? So unless you're now by the time you realize outside of the time frame, then I would just correct it, right? But if you're still inside of the time frame, I would fix it. It's your responsibility as the employer to make sure that your employee filled out their part correctly. Okay. So like the first thing you need to be doing, and typically you're going to be like waiting for them, right? So day one, you give them their form, they fill out section 1, and then you give a table and you tell them to come back with the documents that they choose to present. This is something I didn't mention in the first section, but never tell an employee which document to bring. If you know they're a citizen, don't say to them, come back with your passport. That is actually immigration-related discrimination and potentially document abuse violations that you have on your hands there. So also, like if you know someone's a resident, don't be like, come back tomorrow with your green card. That's completely improper. You give them the notice of the table of acceptable documents, and then you let them choose what they're going to bring back to you. There's 3 columns. They need either one from list A, which is a document that verifies both their identity and their authorization to work, or you need list 1 from list B and 1 from list C, which 1 document verifies their identity and 1 document verifies their eligibility to work. So you need those in combination. Okay. They come back with that document, usually maybe not the next day or whatever, but you should have time, I guess is my point, to make sure that they filled out section 1 correctly. I see a hand up. If you want to type your question in the chat, that would be awesome. Okay, I'm going to come back to some of these questions just because I want to make sure that it's already getting late and we have a lot of stuff to cover still on the next topic, which is the raids. But I'm going to circle back to your questions, and any questions I don't answer live, I will answer to after. Okay, but I'll try to get to the questions we didn't hit. But let's move on just for the sake of time. ICE worksite raids. This is the, scary. This is when they're going to show up to investigate your workplace, and it's going to be more of like an active and a little bit scarier investigation. It's not just going to be them like serving a notice of inspection on you, but it's going to be a little bit scarier than that and might involve some of your employees even getting detained. So, let's talk about this because this is starting to happen more and more often now since the new administration came in. This was always a thing, right? It's not a new invention of the new administration, but it's becoming now more prevalent. So that's why we're going to go ahead and talk about this. By the way, the same for the I-9 inspections. We're seeing a spike. They were pretty high in the first Trump administration, but then COVID hit and they kind of became non-existent. And then they never really came back in full force under Biden. Like there were still I-9 inspections happening, but it never really ramped back up fully. We're seeing a drastic increase already in the first 2.5 months of the administration. So that goes for both, and that's why we're doing this presentation today. If you don't have an action plan in place for this, please talk to me or your qualified attorney and get some advice on this so that you and your employees are ready if this happens. Okay, so let's jump into the meat of it. First things first, ICE arrives at your workplace. The first thing you need to do is call your attorney. Okay, now what I tell people is that the person that they see or that anyone sees when they walk into your business is someone that you need to train what to do if this happens. Now, it seems kind of weird sometimes for employers, right? Because sometimes the person in the front, the first person that someone walking into your business would see is, maybe a lower level employee. Maybe they're like just a receptionist or something, and they're not like a super high level on the hierarchy of your business. So your instinct as a business owner sometimes is not to involve that person in nitty gritty kind of ugly stuff, right? But unfortunately, in this scenario, you need to arm that person with some information. One of them is to teach them what to do if ICE arrives at your workplace. The first thing they should be doing is saying our company policy is to call our lawyer. I'm going to do that right now. And then make sure that they actually have the information. They actually have the name and contact information of your attorney, right? Like, just to say that is not going to do any good if then they don't have the number of the attorney and the person they're supposed to be calling. In addition to this, you also want to make sure that they know who in the company they need to immediately notify that there is an ICE agent at the business. You also want to try to get your lawyer in touch as quickly as possible. So hopefully they can come to the work site and be present for this enforcement action. But if not, you can have the lawyer speak to the ICE officer over the phone. You can also keep the lawyer on the phone during the entire action if you are able to. And if the lawyer is not able to actually come in person. So something to remember is like the scope of this. When the immigration officers arrive at your business, they are going to be free to enter any public area of your workplace, period, full stop. If they want, that is not a public area. So not an area that someone randomly walking into your business could access. Then they have to have a valid search warrant or your consent. Let me say that again, a valid search warrant or your consent. Don't give them consent. Don't give them consent. You're going to find out in a moment that they might not have the right kind of warrant or whatever. The warrant might not be proper. You don't have to consent. If you consent, then the warrant is irrelevant because they have your consent. Okay, so my recommendation is don't consent regardless, because, you know, you might be in a circumstance where they don't have a valid warrant. But if you consented, then it's a moot point. Okay. A valid warrant for purposes of this, right, to access non-public areas of your workplace, and to maybe like search and seize items and what have you, needs to be signed and dated by a judge. Okay. That is is an actual judicial warrant, and that's what's required. We're going to drill down on that in a second. It's going to include on it a time frame when the search is conducted, a description of the premises that are to be searched, a list of the items to be searched and potentially seized. For example, payroll records, identification documents, I-9s, social security, administration correspondence, etc. Okay, all of that should be very specifically detailed in a judicial warrant that then is signed and dated by a judge. Okay. If they come with an administrative, that does not give them the authority to enter a private space or to seize evidence unless you consent. Okay, that's why I'm saying don't consent, because a lot of times they come only with the administrative warrant and then they don't actually have proper authority to enter private areas or to seize items. Okay, so if you're unclear about this, just consent, not consenting is the good way to go. Beyond the public area, if they want to go into any area that's private, they have to have this judicial warrant. Okay, so that is why you need to learn basically how to distinguish between an administrative warrant, which doesn't give them the permission unless you consent to enter private spaces or seize evidence, versus the judicial warrant, which does give them, regardless of you consenting or not, if they have a proper judicial warrant, they can enter a private area and seize items from your business. Okay. You are authorized, if they arrive with an administrative warrant only, you are entitled to refuse their entry into into private spaces, not public, private spaces. Okay. How do you distinguish between the two? It's important to know, right? Because now if you're faced with this situation, you need to know, number one, that there's a difference at all, right? A lot of people are just see the word warrant and they're just like, I give up, right? But there is actually a difference, and one allows things that the other one doesn't allow. So you need to be well informed enough, which is why you're here doing this webinar. So, pat yourself on the back for that, at least. You need to be able to distinguish. So an administrative warrant usually has the seal or label of an agency like the Department of Homeland Security. It's usually going to be signed by an immigration officer or an immigration judge, and the title might contain the word alien in it, or a statement that the authority to issue this warrant is an immigration law section, right? It's like an immigration law authority for the warrant. By contrast, a judicial warrant, which is the one that will allow them to properly go into private areas, regardless of you consenting or not, is issued under the authority of a federal court, signed by a federal judge or federal magistrate, and will state the address of the premises to be searched and the time period in which the search must occur. Okay, so those are your main differences. Okay, so if they present an administrative warrant, it might be either a Form I-200 warrant for arrest of alien or Form I-205 warrant for removal deportation, issued by DHS for the arrest of an employee. If they have that, they're still only allowed into the public areas of the workplace. Okay, keep that in mind. They are going to serve the search warrant on the company representative or the receptionist, and then they're going to alert other agents to enter the premises. You can accept the warrant but not consent to the search. You don't consent to the search is still going to proceed, but later you have grounds to challenge. Okay, so this is like if it's a proper judicial warrant and you're like, okay, that's a proper warrant, but I still don't consent, they're still going to do the search, right? They're because they have the warrant that allows them, but at least later you can challenge if, you know, it happens that it did turn out to be improper for whatever reason. So, you know, like I said, I would just across the board, not consent, like have that be like in your brain, like you're not going to consent regardless. That doesn't mean that it's not going to happen. But at least then you made your objections known. Okay. So depending on the kind of business that it is, ICE can demand that equipment be shut down, that no one enters or leaves the premises without permission. They might ask to move employees into a certain area for questioning. They might split. They don't come alone. Okay, so they're coming in multiples, the officers. So they might split the agents up. One of them might go to question employees. Others might search and seize items that are listed on the warrant, like records and I-9s and payroll records and other items at the business. So it's really important that you guys are paying attention to what's going on. So you need to figure out who is going to be empowered at your company to be like one of the people that's going to deal with this, because you're going to need more than one person. You really want someone from your company to follow each agent around and document what's going on. Okay, so if you only have like one person that's empowered to with any kind of responsibility at your company for this stuff, what are you going to do if one agent goes off with the employees and the other one starts searching and seizing items? You can't split yourself in half. So you need to have, you know, a couple of people that are trusted in the company so that you can really know who's going to be doing what in the event that this happens. Like you see here, writing down the names of the supervising ICE agent and then a name of the attorney assigned to the case. If you see that on the warrant, make sure you get a copy of the warrant so that you can send it to your lawyer. Make sure you examine it carefully to ensure that it's signed by a court and that it is written on there and not outside of the time frame written on the warrant, and that it's also describing anything that is to be searched or seized. You want to have at least one company representative, like I said, following each agent in the facility. You want to have them take notes and even videotape what's going on. It's really important that you're writing down anything that they seize, but that you also are asking to make copies of the item before the agent takes it. If they don't agree, you can likely obtain copies later on, but I would prefer you to get the copies right then and there before they take the items away, before the documents get carded off, right? If the agents present a valid search warrant and they want access to something that is locked, because remember, the valid judicial warrant is going to allow them to access private areas. So if there's an area, access it, and they have a proper warrant, then go ahead and unlock it. You don't really have a choice at that point. You ought to be asking for reasonable accommodations. So let's say they want to see something that like you can't operate your business without it. Then you need to try and reason with them not to seize it, or to at least let you make copies before they seize the original. You don't want to block or interfere anything that they're doing. It's really important that you, as terrible as this is, and as much as you're going to be enraged and probably pretty freaked out, you need to try and stay calm the best you can and cooperate. Okay, the more confrontational you get with the agents, the worse it's going to end up. Okay, so try to stay calm and cooperate as much as you can without letting them steamroll you, right? Like, you can still not consent to things. You can still ask for accommodations. You can still follow them around and take notes, but do it in a way that is as unconfrontational as you can possibly be, because that's going to be the best outcome here. It can get a lot uglier if you're trying to block them or interfere, or even just being like overly confrontational. Like I mentioned, you don't have to give them access to non-public areas if they didn't present a valid search warrant, but if they did, go ahead and unlock and let them in. If there's items outside the scope of the warrant, and they're trying to take it and you're like, that's not in the warrant, make sure you object and get it hopefully on tape, or at least in writing, that you objected to the taking of that item, since it wasn't described in the warrant. But okay, let's get serious here. So you just need to get like your objection on the record, basically. You want to think about like materials that might be privileged, right? So if there's items that they're trying to search and seize that might be subject to like attorney-client privilege, you need to try and protect that material as much as possible. Try to record in your notes what documents were being taken by the agents, and especially if it was designated as a privileged material. Like a lot of times that will include letters or other information from your attorney. Tell them that that information is privileged. Request that your documents that are subject to privilege not be inspected until you're able to speak to your lawyer. Again, they might not let you do that, but you have to at least make those objections and those comments out loud, and have it be recorded that those objections were made, and that specific items ought to be privileged under attorney-client privilege. You want to ask for copies of any items that were seized during the search, and then have them leave you with an inventory. That is really important, because you need to know exactly what was leaving your office with as much specificity as possible. Okay. Don't allow anyone from the company to give statements or be interrogated unless you talk to your attorney first, please. And also, and we're going to get into the situation with your employees in more detail in a moment, but you want to inform your employees that they do have the right to choose whether or not they're going to talk to ICE. But as an employer, you ought not be directing them to refuse to speak to agents. So what you're telling them, and we'll get into this more in a second, but is of their right to remain silent or to talk if they want to. But what you ought not do is say, don't talk to the agent. Don't say anything. Keep your mouth shut, right? That is improper. Don't hide your employees or assist them in leaving the premises. That's a big no-no. You can get in a lot of trouble for it. Don't provide false or misleading information. Don't deny the presence of people, oh, we're looking for, Joe Blow. Oh, Joe Blow's not here, when really he's, there in the back or something. Don't start shredding documents in the back room while the agents are in the front. That is all potentially criminal activity. So please don't engage in any of that. As much as you are gonna maybe have the urge to do something like that out of self-preservation and protection for your business and your employees, you ought not do any of that. While all of this is going on, don't forget about your employees. They're going to be probably pretty scared, as well as, just as much as you or more so. This can go on for hours, right? This is not something like that is over in 10 minutes. So this can last for a while. So if you have employees that they need medication, or they need to eat or drink because of a medical condition, they have kids that they are supposed to have picked up from school an hour ago that are sitting there waiting for them, you need to communicate that to the officers so that hopefully you can accommodate any medical or other urgent health or welfare needs of your employees. Your employees have the right to remain silent and the right to talk to an attorney, which we already mentioned. You can ask the officer if your employees are free to leave or not. If they're not free to leave, then they have the right to an attorney. Even though you shouldn't instruct your employees to refuse to speak to ICE, they also have the right to remain silent, so they don't need to answer any questions. The nuance here is that you, as the employer, ought not be telling them not to say anything. What you need to be telling them is that they have the right to choose whether they want to remain silent or answer the questions. That's their right and their right to decide. And also, if they're not free to leave, they have the right to a lawyer. Employees are not required to answer questions about their immigration status, where they were born, how they entered the United States. They can exercise their right to remain silent and ask to speak to an attorney. If ICE tries to pull one of these, it's like a little thing that they do where they try to, instead of getting the information verbally, they try to do it with physical movement. So basically, go stand in, that side of the room if you have XYZ immigration status. Go stand in that side of the room if you have, if you're a US citizen or something like that, right? That is the same thing as verbally communicating to ICE, right? So they kind of try to trick you, right? Because they think, oh, the right to remain silent. Well, they're not saying anything out of their mouth. We're just telling them to stand here, stand there. Doing that is kind of the same thing as answering questions, right? So their right to remain silent includes the right not to move into the group that they're asked to move into. They shouldn't go to the wrong group, because that's almost like you lie, right? Stand over here if you're a foreign national, stand over here if you're a US citizen. If a foreign national goes to the US citizen group, it's almost the same thing as verbally lying. But what they can do is move to a non-designated area for any particular group, which would be kind of like the bodily motion equivalent of being silent, right? So think of it in that way. Your employees can also refuse to show their identity documents that disclose their nationality and their citizenship. They're probably going to be detained if they do that. So, keep that in mind. If they're detained or taken into custody, which could very likely happen. I mean, that's kind of, especially under this new administration, the point of this type of action is to find people and take them into custody. Be sure that you contact their families right away to let them know what's going on, and also that you pay them any money that they're owed for their work. You're probably going to end up doing that through a family member or whatever, but don't, well, that guy was detained, so I don't need to give him his paycheck type of thing. Okay. Make sure you're paying them and contacting the family. This doesn't all end when ICE leaves your businesses. They can review items to be seized, after reviewing the items to be seized. they can also have investigations like surveillance and things that can happen after the fact. So, you know, we're not gonna get into specifics of that because it's very scenario and fact specific, but just understand that when they leave, it doesn't mean that everything is over. Potentially, there could be other law enforcement agencies involved in this, the Department of Labor, sometimes state and local police. We're seeing, if you're following the news, you're probably seeing stories about different local and state police departments that are signing on to an ICE memorandum, which is actually empowering them to be immigration enforcers. It's scary stuff, but it's happening a lot around the country. It's happening for sure a lot right here in Florida and in my backyard of Coral Gables. So, you know, you need to be aware that potentially there are other organizations involved beyond just ICE. Knowing your responsibilities and your rights as an employer is really important. So please remember that this is just the beginning of your education on this topic. You really ought to speak in more detail. Remember, you want to document everything. You want to make sure you recorded the agents' names, the actions taken during the raid, any items that were seized. You're going to need that information after the fact and be able to have that for your attorneys in case any action needs to be taken afterwards, especially if there was improper searches and seizures under an improper warrant, etc. Communicate with the affected employees' families promptly if any of them are detained. Make sure they receive any support that they are going to need, because this is going to be probably a really challenging time for them if one of their loved ones was taken into custody. And then also, just like on a more dry, technical, less personal, you want to think about if you're forced to shut down or anything like that, that is then causing you for a delay in your work, and maybe you're not going to be able to deliver on a contract in a timely way or something like that. You need to make sure that you're thinking about any potential claims that might arise out of that. Okay, so we're almost done here, but I want to give you guys some tips on, like, you can't prevent this from happening, right? But what you can do is be as well prepared as possible. You're taking the first step today by doing this webinar. So I commend you for taking the time out of your busy day to listen to me talk about this stuff and to get better informed. But it doesn't stop with today. Today is step one, not the finish line. So what you really want to think about is creating a crisis and management response team. You want to make sure that you are up to date on all the emergency contact information for your employees. You want to make sure that you have a plan in place on who's going to interact with the law enforcement agents and make sure that those people are trained. You want to make sure that you are reviewing contracts to know what happens if your work is delayed or disrupted by the works enforcement action. You want to have all your hot numbers ready, attorneys, union reps, anyone else that you're going to need to be contacting right away. You want to make sure that the frontline person, that is the first person the officer would see if they walked into your business, has that information and they know how and when to use that information and who to call. That's really important. And of course, which is how we started this presentation, you want to audit your I-9 and E-Verify processes to make sure that you're compliant for both current and former employees as required under the law, because they, for sure, if they do one of these actions, are going to be, in addition to potentially arresting and detaining some of your employees, seizing your I-9s and then starting an enforcement action on your I-9s as well. Okay, a crisis management response team, very important. This team should be, you know, people of some responsibility and level of, you know, management at your company. And some of the things that they need to think about are who's going to, on this team, contact the legal representative, the lawyer, the legal team. Have we set up files for terminated employees' I-9s? Who's the main point of contact for coordination with ICE? How is the company addressing notifying family members of the employees? Are you going to have outside counsel with direct or indirect access to ICE? If you have outside counsel, like a lawyer that you're going to have communicating directly with ICE, you should have a G28 notice of appearance ready to provide to ICE. So G28 is like a form I use basically every day in my law practice, which is basically just saying that I'm your lawyer. And it's like a very simple form to fill out, and it says that we represent you, basically. So that's what that is, just FYI. And then also like thinking about public relations and communication issues. Internally, trying not to cause an internal crisis, but also externally to the public, because this can unfortunately be damaging to goodwill and reputation. So you might have a bit of a little public relations issue on your hands that you have to think about in advance how you're going to deal with that. Okay, almost to the finish line, guys, here, and then we'll go through the rest of the questions. Identify a primary contact in your organization who's going to handle communications with ICE. Make sure that that person is trained, right? So don't just identify the person, but then make sure that the person is trained up and really knows like what to expect and what to do. You're going to want to create this detailed plan. You're going to want to have it outlining steps that you're going to take exactly if and when ICE arrives at your job site. And some of the things that ought to be included, this is the bare minimum. It should obviously include other things, but the bare minimum here is procedures for verifying the warrants, right? Administrative warrant versus judicial warrant. What do they mean? How can you tell the difference? All the stuff that we went through earlier. Guidelines for employee interactions with the ICE agents and the employees about their rights, and communication protocols for notifying legal counsel immediately upon an ICE visit. Educating your employees obviously is something you really need to think about. I know you don't want to scare people, but at the same time, knowledge is power, and it's going to allow you to be best positioned if something like this does happen to you. Informing your workforce about what their rights are is really important, and making sure that they know that they have the right to remain silent and request legal representation if they're approached by the agents. I think this might be the last substantive slide. There might be like one more. Reviewing your contracts, making sure that your upstream contracts obligations around your workforce and any exposure that you have in the event of a raid, making sure subcontractors or staffing agencies that you work with are compliant with immigration laws, making sure that it's in the contract that you have with those agencies, okay? Like, it is really important when you're using agencies or subcontractors that it's very clear in the written agreement between your company and that agency or subcontractor whose responsibility it is to verify the employee's work authorization and to stay compliant with I-9 and E-Verify. Also include in your contracts a clause that they ought to be providing you only with legally authorized workers. That way, potentially you pass some of the liability off to other agencies. But, if you don't put it in writing, then potentially you're both going to be held responsible. So that's something that you need to consider. So making sure that your contracts are really buttoned up tight and with this topic is really important. Here are some resources. Obviously, don't write this down. You're going to have access to this presentation later. So these are just some good websites that talk about know your rights, that talk about if, God forbid, someone gets detained, how do you find them? Like the locator tools, some other interesting information about warrants and things like that. Okay, so here's some resources for you. And to wrap it up, obviously, I wouldn't be a good webinar presenter if I didn't just tell you a little bit quickly about the services of my law firm. Nero immigration law, we do all of the stuff that you see up here on the screen. Today we were mostly focusing on the far right-hand side of the screen, employer immigration compliance. You see that we can help you with internal auditing, hiring and immigration practices, best practices, training for staff and management, drafting your employer employment verification policies, your employer immigration policies, helping you with create immigration handbooks for your hiring managers or HR managers, representation before ICE in the event of an audit, representation before ICE after an audit to negotiate your fine, e-verify training, also helping you with a raid situation if God forbid that happens to you. So that's kind of the services surrounding, and I can create like bespoke packages for you that are specific to your type of business as well. Another thing that we can do is presentations like this for internally your business or your clientele or your organizations that you're in. So if you think that other audiences that you are a part of might benefit from a similar presentation, please approach me. I'd be happy to do that for you as well. Then, just to tell you a little bit more about our other services, we handle all kinds of non-immigrant visas and green cards, both work-based and family-based, other types of ancillary benefits, and then also citizenship. So everything you see up here on the screen, we are really well versed at and can help your business or your clientele. Okay, so you might have noticed, and if you haven't, I am jealous because I've been just on like news overload in the past 2 months, but there's a lot going on in immigration law lately. So how do you stay up to date? One easy way is to subscribe to my law firm's newsletter. We send it once a month, so we're not gonna like shoot you out on the newsletter like every day. I will give you the caveat that if there's like a very important breaking news situation, we will do like a supplementary email blast to make sure that everyone gets that information. But if you want to subscribe, here's how you can do so. Scan this QR code, and I think you have to fill in some basic information, and then you'll be kind of on our list. And here's all my contact information. You have it there in writing, but you also can scan that QR code and get access to my full contact information, which includes social media, which is another really good way to stay in touch with me and stay up to date on what's going on, because we do a lot of social media posts. And also it's not here, but I think it's on the QR code. We have a YouTube page now. This presentation is going to be up on that YouTube page. We're also going to send you access to the recording directly to you. But then later, if you can't find that email or what have you, you can always go to our YouTube page to look at the recording and also to see other things that we've recorded. It's a newer page, so I don't have everything up there, but as time goes on, we'll start uploading all the sessions that we do to that page. So that's another way for you to stay in touch. Okay, so that's it for the content. Thank you so much for everyone for participating. If you want to hang out, I'm going to answer some of these questions right now. If you have to go, but you did a recording, or you can shoot me an email and be like, hey, you didn't answer my question. So please answer it. So I'm more than happy to answer your questions one-on-one as well. So don't be shy. But let's go back. All right, I already answered that one. So let's check that one off. Okay, the penalty fees don't accumulate by day, right? So it's not going to be like for every day you had something wrong on your I-9s or that you were employing an unauthorized worker, like the fee is compounding on a daily basis. You might have heard under the Florida law that passed 2 summers ago with the E-Verify mandate, that once they find you to be in violation, they're going to start fining like $1,000 per day, which is insane. I haven't really seen that happening yet. Anecdotally, if you have heard of that happening, I would love to hear a little bit more about it, because I haven't necessarily seen that happening. But this is not necessarily like that, right? Where the fees are like compounding on a daily basis. Typically, it's going to be like per form your violation, right? So you're not going to be hit with multiple violations on one form, right? You'll have like one form that's non-compliant, and so you'll have like one penalty on that form. Hopefully that answered your question. Okay, next we had a question saying, if we identify that an I-9 was misplaced or missing, how do we go about addressing that? Okay, so I'm glad you brought that up, because usually I talk about that in like my longer I-9 presentations. And I didn't mention it today, so thank you so much for that question. When you're doing your audit, if you're like, oh my God, we don't even have an I-9 at all on these people, do it then. Okay, it's always better late than never is like the idea, right? Like you're definitely gonna get a fine for being outside of the time, because you messed that one up, right? Like you didn't make it in the first day of work for pay with the employee, and by the end of the third day, business day, you verified and filled out your employer section. Like can't rewind the clock, can't fix that mistake, but it's worse if there's just no I-9 at all. So like you would get a worse penalty than you would if the problem was just that you did it outside of the required time frame. Okay, so better late than never is your, go-to mindset on that. The thing you want to be really careful on, and I know all of you are super honest and ethical and you would never do this, but don't backdate stuff. All right. Oh, well, I'm just going to do it now, but say that I did it, a year ago when this person started working for me. No, like they're not stupid. They're going to know. And one of the main ways they know is that probably the form that you're using now is a version that wasn't in existence when you put that you were dating it, if you backdate. Okay. So it's like really easy to get tripped up that way. And it's like one of the first things they look for. And it's one of the first ways that they know that you lied and put like a wrong date, you backdated. So don't backdate, put the current date. Like I said, you're still going to get in trouble, but it's less trouble than you would get in if you just didn't have it at all. So, that's kind of the way you should approach that situation. Okay, so next we've got is the staffing firm responsible for storing and obtaining I-9s? So I think I already answered that in the presentation. It is whatever the contract says that you signed with the firm. So the liability ought to be on the staffing firm. But if the contract doesn't say that, then you're kind of in like a gray zone, right? And then I would be like kind of worried about that, and maybe even doing it as the employer. So you definitely want to have in the contract that it's the responsibility of the staffing firm and also the liability of the staffing firm. But it has to actually be in writing. That is not like a given rule. You have to have that in writing in your contracts. I've got a really good contract attorney I can introduce you guys to if you need help with contracts. But making sure that you are contracting away as much of that responsibility when you're working with subcontractors or staffing firms as possible. That doesn't mean that you're not going to get in some trouble potentially, especially if there's like really egregious violations. But the more you are protecting yourself in the contract, that it's on the staffing firm or the subcontractors and not on you as the like end user of those employees' services, then the better off you're going to be on that one. Do we have to ask our current employees for updated I-9 documents once they expire? Great question. This deals with re-verification. Again, if you want to chat more offline about this stuff, it can get a little complicated, but there are certain types of employees that you do need to re-verify when their documents expire, and there are other ones that you don't. Okay, so just to give you the two big ones, you don't need to re-verify US citizens and you don't need to re-verify permanent residents. So even if the green card expires or the passport expires, you don't go and re-verify the people. Okay. If the work permit expires, then you do have to re-verify the people. Or if they have like a work visa that allows them to be working for your company, but only like within certain dates that it's valid, then yes, you do have to re-verify those people. So some yes, some no. If you're ever in a conundrum on that, you can come to me directly with questions. But additionally, the M274, I think, is the correct letter and numbers. Published by USCIS. It's on I-9 Central, which is a website that's part of USCIS that has like a lot of I-9 related information in like one place. But it's part of the USCIS website. So if you go to uscis.gov, you can just find that there by clicking around, but they call it like I-9 Central. There you'll have the handbook for employers, and they really go into like great detail. It's hundreds of pages about like when you re-verify and when you don't, and like how do you do that, because there's actually a section on the form that's different now since they the last update to the form that was done, they changed it and they made it like one of the supplements. It used to be like right on the form. So there are procedures for doing that, but knowing when you're actually required to do that and when you're not is really important. But general rule of thumb, and the easiest thing to remember about that is don't re-verify US citizens or permanent residents, even if their card or passport expires. A lot of other people you might need to re-verify if they're employed pursuant to like a visa or a work permit, then probably yes, you will need to re-verify that. And then you need to go down the rabbit hole of like all the rules involved in that. Something important to think about with this as well is like the document, even though for a resident, I mean, specifically a green card and a US passport, even though you don't have to re-verify it when it expires, it needs to be valid when they present it to you. So when you're actually doing the checking and filling out and like in the moment, any document presented to you has to be valid, like inside of the validity dates. Now, if a passport or a lawful permanent resident card, a green card, expires then in the course of their employment, as long as it was valid when you verified it in the beginning, you're good. You don't have to re-verify them. But with the other types of documents like work permits and work visas, you do. Okay. There's a lot of like weird rules. That's why I'm telling you to go down the rabbit hole and be really careful with it, that involve like automatic extensions on certain types of work permits and things that can get a little bit like convoluted. And so it can get a bit confusing, I admit. So please, you know, if you're ever in that situation and you're like, I'm not sure, like I'm confused, definitely reach out to me. I'd be happy to answer your questions, and check out obviously the M274 manual for information about that, because you don't want to then re-verify people you're not supposed to be re-verifying, or think that someone is not authorized to work when they are, because their work permit is expired, but maybe they got an auto extension that's in force. And so they actually are authorized to work, even though the plastic card might have already expired. So there's like a lot of little nuances there to keep in mind as well. Okay, so that was that one. Someone is asking me to repeat the definition of public versus non-public area. If it's an area that someone off the street basically could walk in, right? Like if the Uber Eats guy can come into the area of the business, then it's a public area. Okay. If it's an area that is not open to the public, or even, you know, taking it to another level, locked potentially, then that is a private area. So I'm going to say this is only in the public areas, correct? But that was, they were asking the question in the moment when I said something, so I don't know what they were referring to specifically. So Parry, if you want to ask me that question one-on-one, I'd be happy to answer it one-on-one. You are going to receive the presentation by email, so I got that question. You are also going to be able to access it on the YouTube channel. Give us a little patience with that. You know, it's not going to be today that you get a copy of this presentation, but hopefully by tomorrow and Monday at the very latest. Okay. I have a very specific question about a Venezuelan national on a work permit asked by an anonymous attendee. I would love to answer that question with you one-on-one, just because it's like very specific and it depends on what the work permit was based on. But just to give you guys a general answer about Venezuelans that had TPS on Monday, there was a temporary injunction issued by a federal court saying that the premature termination of the or revocation of the extension of Venezuelan TPS is temporarily enjoined. And so actually USCIS did put out on their website, I think it was yesterday, information about that, saying that basically all those people's employment authorization was automatically extended due to the temporary injunction. So if you want more, anonymous person that asked that question, if you want more specific information about that, reach out to me and we'll talk one-on-one about it. But there's kind of like a general notification about that. I have someone asking me if they can enter. This is a really good question. You guys are an amazing audience. Thank you. You're asking some really good and well thought out questions. So I really appreciate that. I have a question here that says, can we enter tenured employees into E-Verify? They're not new employees, but being verified is kind of like part of our audit. So the answer is no, you shouldn't be running existing employees through E-Verify. Okay. What you want to do is the date that you start using E-Verify, that's when you needed to start running people through E-Verify that joined your company as of that date. You are not supposed to then go back like, okay, I joined E-Verify, so now I'm going to take all the people that have already been working for me for weeks, months, years, and I'm going to run all them through E-Verify. That is not proper. But anyone that started work as of the date that you joined E-Verify, then those people all need to be run through E-Verify. And let me say that again and emphasize a different word. Those people all need to be run through E-Verify. You'd be surprised how many employers I talk to that are cherry picking who they're going to run through E-Verify because they know Joe Blow person is not going to pass through E-Verify cleanly. So they're not even running that person through E-Verify. That is also improper. Once you start using E-Verify, you are obligated to run everyone that comes into your business or not comes in, starts working for your business. As of the date you sign on to E-Verify, you're obligated to run them through E-Verify. Okay. The people from before, no. The people from the date that you joined E-Verify forward, yes. And that means all the people, not just some of them. Okay. That's a great question. Thank you for asking that question. I think that's it. I think I answered all the questions. Hopefully I didn't miss any of your questions. I think I got them all. So, wow, I really wanted to not go over 90 minutes. Well, we did 94 minutes. Thank you guys so much. This was a long presentation with a lot of information in it. So I really appreciate you sticking it out to the end. And for those of you that had to jump off early, again, you'll be getting this recording. So I'll see you on the recording. Thanks everyone so much. Be safe out there, be well informed, and please feel free to, reach out to me with any questions or problems that you have. Have a great rest of your week. Thank you so much for participating.